Hi, everyone. This is Alex Reeby, immigration attorney with Maria Sario. So today, the title of this talk is "Can you get a green card because you've been in the United States for 10 years?" That's something that I hear all the time. I've been here for 10 years. Can I get a green card? Can I get a work permit? The short answer is no, not just because you've been here for 10 years, but the longer answer is yes, it is possible to get a green card through something called cancellation of removal. And one of the requirements is that you've been in the United States for at least 10 years. So what does that mean? Well, if you've been in the United States for at least 10 years, whether you entered illegally, whether you entered with a visa, whether you entered multiple times, doesn't matter. But if you've been in the United States for at least 10 years and you're in removal proceedings, then you might be eligible for something called cancellation of removal, which is a pathway to a green card. It's a way to eventually win a green card. Okay. So what do I mean by that? Well, let's say you're in removal proceedings. How would you get placed in removal proceedings if you've been here for 10 years? Could happen a variety of ways. Maybe you applied for something and it got denied, like you applied for asylum and it didn't get granted, or you applied for a green card and it didn't get granted. Maybe you were stopped by the police for something like a DUI. Maybe you were like near a port of entry. Maybe you were going up to Canada and got apprehended by immigration. At any rate, if you're placed in removal proceedings and you've been here for at least 10 years prior to the point at which you are placed into removal proceedings, prior to the date, there should be a date of your on that document that you're first given, assuming that it's a valid document. Then if you have the 10 years, then you might be eligible to apply for cancellation of removal and could potentially get a green card that way. So what that means is you have to be here for at least 10 years. And then there's 3 other requirements. The first is that you have to have U.S. citizen or lawful permanent resident, parents, spouse, or kids. You have to be a person of good moral character. So there's sometimes some certain types of criminal convictions might knock you out of eligibility. For example, if you have like sometimes different types of theft convictions or fraud convictions. And then lastly, you have to show that your U.S. citizen family or your lawful permanent resident family would suffer exceptional hardship, would suffer more than a normal family if you were deported. So when do we see cancellation or removal? Well, when I have clients that come into my office, they've been here for at least 10 years, get put in removal proceedings. They've got some kids. They have maybe 3 kids. The kids rely on them for financial support. Maybe one of the kids has ADD or some educational issues. Maybe mom has some emotional issues, or dad has some medical issues or something like that. Maybe they're from a particularly dangerous country that they can't get, that they couldn't leave. We have to show that the family would suffer if either they were separated from the person in removal proceedings, or if they all had to relocate to that new country. So maybe you're from, El Salvador, and you have small children who are girls, and one of the factors might be that it's particularly dangerous for young girls coming from the United States to live in El Salvador. That might be something that we use to kind of help our argument that the family cannot go to El Salvador. They would suffer exceptional hardship. So there's an application you fill out. It's called an EOIR 42B. There's a filing fee. It's $185. And then your case, and then you file that. You pay the filing fee. You file that with the court. And then as soon as you do that, you can actually apply for a work permit. And so you'll have your work permit while your case is pending. And then you'll eventually have your individual calendar hearing where your attorney and you will explain how you're a good person, how your family will suffer, And then if the judge grants the application, you'll ultimately get your green card that way. So that is a way you can get your green card, never have to leave the United States, and you do have to be here in the United States for at least 10 years in order to benefit and apply for that EOIR 42B. So there is no magic 10-year law. However, people say that because this way of getting a green card, you do have to be in the United States for 10 years. So it's one of the requirements. It's not all of the requirements, but it is one of them. And so then it's up to you and your attorney. And it's very helpful to have an attorney in these cases because they're very fact and evidence specific, because hardship can be evaluated many different ways. And so you really have to have an attorney sitting there with you with your documents and figuring out what's the best way to present this case so that I can really paint a picture to the judge that this family would suffer. Like, how do I do that? What is a convincing declaration? What evidence do I need to show? Maybe there's taxes that need to be filed. Maybe there's letters from the teacher. Maybe the teacher comes and testifies. What is it that's going to really convince the judge that this family would crumble without this person? That's what's needed for a cancellation of removal application. And that's the 10-year law that we currently have in the United States. Thank you so much for listening, and we'll see you next time.